Today is Friday, June 24th, 2022. It's 11:37 a.m., and I'm calling my Lapeer County, Michigan court-appointed assistant, John Miller, or Fred Miller.
Fred Miller.
Hi, Fred. It's Rick Schwartz.
Good. How are you?
Well, I was doing okay until I went into court and got set up on the 24th.
Well, I understand. That's what they were going to do.
Yeah, they did that on purpose, too. And, Fred, you have copies of all of the contact that I had with John Miller before court. He did that on purpose. How do I file a complaint against him for that?
You can try to bar grievance commission. That would probably be the best way to do it. All right.
But I mean, I got to do something like real fast because they're jerking me around. I have no idea. I have no idea when my court date is.
I don't know that they've said anything.
I know
I don't know offhand.
What I don't understand is what about how is this still a case? John Miller, I requested on 11/27. Or I'm sorry, 11/17/21. I walked right into his office and handed him documentation, asking him for all of his evidence. And I also went into Judge Holoka's office and handed him the same document to his secretary. They have proof of that. I've been asking. They can't use that evidence at all. They have to suppress it.
No.
Why?
First of all, Judge Holoka doesn't have any evidence. He wouldn't have anything to do with that. He's a trier fact. He doesn't get anything to do with the date of trial.
I know that, but what I did is I gave that to him, so John Miller can't say that they never got it. I handed him. I even think I put it on the internet, a copy of the letter that I sent to, or that I handed him, asking him that he has to dismiss his case with prejudice because I asked him. When I met him in June, here's what happened in June. In June of 2021, he told me, he said, I will make this case disappear. And he said, you can go anywhere you want, just don't come back. And he said, get out of Michigan and don't come back. And I was looking at a house in Georgia, and I said, okay, fine, let me go and start looking around. And I said, but I can't go anywhere without any kind of documentation that I have the right to do so, because I still have this case. If I get caught in Ohio or Kentucky or something, they're going, what's going on, and you have a case going on. And then I still had that device, that Intoxilock device. That's another thing that's a scam. I was eligible to have that thing removed in February, and this company they could care less about the law. And the Secretary of State could care less too, because that's just more business for them. It's repeat business. They just drag it on forever. And I was eligible for this.
Yeah, but John Miller doesn't have anything to do with that, and neither does this court. So they don't have any control over that. They don't have any say over it. It's nothing that they can do.
No, it isn't. It's all state and county collusion and sabotaging my effort to live.
Well, but then you got to prove that to them, and the state, they don't care.
You know what? I'll call. Why can't I call this? I had a Secretary of State, Judge Soma, that I made a legal request, and I had help. Have you ever heard of the Rutherford Institute? John Whitehead. He's in Virginia. This guy's a constitutional lawyer. His company, his organization helped me.
That has nothing to do with your case in front of Lapeer County, though. That's a separate issue. They have no control over it.
I don't believe that at all. I believe that John Miller called the Secretary of State up and had him blew up my car. They had it in June when I met John. I met him in June, and I said he made me that offer. He said, I'll let that case go away. And I told him, I said, I want to prosecute those guys. I said, I want to go. I want to move, but I want to come back, and I want to prosecute those criminals that made this false claim against me. And then all of a sudden, when I did that, this is no kidding. That was in June. In July, I was driving my vehicle and with this interlock device, and it took a picture of me. I left the vehicle for 15 minutes, and it took a picture of my empty vehicle, and the Secretary of State said that they called it failed a rolling retest, which is impossible to do with a parked vehicle, and they revoked my license for 3 months for no probable cause, and then I had to fight to get it back.
John Miller has nothing to do with that. okay?
I don't believe it.
That is not his control. He cannot. Well, that's the way it is.
Okay.
So I don't really care.
Well,
I don't know what to tell you.
Well, what happened to when I had my court date on the 26th, and this thing, my device just blew up. It just failed on me.
It's not John Miller's problem, and it's not this court's problem. That's your responsibility.
It's not my. How can you say it's my responsibility when a state mandated vendor blows up my vehicle? I had nothing to do with it. That's the Secretary of State's problem. That's because
no, it's not. Unfortunately, okay.
So in other words, they can do whatever they want. They strapped a car bomb on me that failed 2 times. Once it took a picture of me when I wasn't even in the vehicle, and then just before my court date, my trial date that I've been struggling for 34 months, my vehicle blew up again and just failed. And then they spent 16 days trying to get it replaced. I was sitting in my driveway for 16 days with their tech support people trying to figure out how to get it done, how to get it how to get it fixed. And then they told me they told me on Wednesday, the Wednesday before my trial, that they sent me a text message saying that we're going to order the parts, we're going to order a new unit, and we'll let you know what's happening. And I sent that sent that text to John Miller, so John Miller knew about that. And then it was Friday.
It's still not his problem, okay? The bottom line is it's your responsibility to get to court. If you got to call Uber or whatever, that's the problem.
You know what? That's ridiculous. I live 20 miles from town. There are no Ubers. That's all they did is they set me up. If I can't do it, the Secretary of State's state mandated vendor is responsible for the failure of my equipment. And that has nothing to do with me. That has nothing to do with me. And the state blew up my vehicle so I couldn't use it. And then these idiots are going to try to put me under arrest because I can't get an Uber to drive me 3 hours. I'm 3 hours from Lapeer now. Do you understand that? What was I supposed to do?
I understand that, but it's not the court's problem. It's your problem.
It's not No, it's not my problem. When I have.
Well, the court thinks it's your problem. And they don't care.
I have failure of government that goes all the way up to Governor Gretchen Whitmer. And this.
Well,
that's the truth. This is.
Well, that's what you think, unfortunately. That's not what the facts show. Okay?
What facts?
You got to have facts to substantiate it, and you don't have them.
What facts? Right? Here's what facts that I have. In 2016, the state of Michigan allowed me to buy a car, plate it, and insure it. Then they told me that I couldn't drive it until I paid $4,000 in driver's oversight fees that I couldn't pay. And
John Miller has nothing to do with any of that.
No, it's senior citizen abuse on the federal, state, and local level. That's what it is. Well,
and I would disagree with you, but I got to go, unfortunately.
No, you know what? I need to know what to do. I need to file a motion. John Miller has to suppress that information.
No, I don't think so.
Why?
I don't think you got enough legal basis to do it. All right.
I asked him on 11/27 for all of his evidence, and he refused.
File your motion and see what happens. Okay.
I need you to tell me how to do it. Fred, you motherfucking idiot, fucking asshole. Today is Friday, June 24th, 2022. It's 1:37 p.m., and I'm calling my Lapeer County, Michigan Judicial Court appointed assistant who's supposed to answer questions because I'm acting as my own attorney, or I'm feebly trying to act as my own attorney, but Lapeer County makes it impossible with people like Fred.
Thank you for calling Frederick J. Miller, PC. We can't take your call right now. Please leave a message and we'll get back to you as soon as possible.
At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Today is Friday, June 24th, 2022. It's 1:38 p.m. I called Fred Miller earlier and was trying to get answers to questions that I had, and he hung up on me. I've got a bunch of questions that I need him to help me with. That's what he's being paid for by Lapeer County, to answer questions. I've got a bunch of questions, not only my complaint with John Miller, but Fred, you got to call me back and give me a date and a time next week where you can answer questions that I have crucial to my defense. My number is, call me at my office number is 810. My cell number is 810. Fred, I've been my own attorney for the last 2 years, and I'm getting nowhere because you won't help me. So you do what you're supposed to do and answer questions. Call me back. Either that or take yourself off this case and have Lapeer County get me a new assistant to answer questions before the next court case. Either move it or lose it. Call me back, Fred.
If you are satisfied with your message, press 1 to listen to your message. Press 2 to erase and re-record. Press 3 to continue recording where you left off. Press 4 to send your message with normal delivery. Press 1 to send your message with urgent delivery. Press 2.
Urgent.
Thank you. Your message has been sent. Goodbye.
Goodbye. Call back, Fred. On 6/10/22, I sent this email to John Miller, Lapeer County, Michigan prosecuting attorney. I've made all my information anonymous because I'm a private citizen and I have that right to do so. I'm dealing with public servants who don't have that right. I sent copies to Governor Gretchen Whitmer, Attorney General Dana Nessel, Senator Kevin Daly, State Legislator Gary Howell, Michigan State Secretary of State Judges Hannah Meyer and Judge Soma, Lapeer Community Mental Health Law Enforcement Liaison Danielle Giles, Attorney Fred Miller, who is my court-appointed assistant. I'm acting as my own attorney. I have been trying to act as my own attorney since June of 2020, and Lapeer County could care less about my right to do so, my constitutional right to do so. I also wrote to Alex Killam, Nate, and Brandon of the Intoxilock Customer Advocacy Group. This is an 11-page letter, and I said, please acknowledge receipt of the 11-page email and attached PDF file. And the letter reads, hello, Mr. Miller. Last June, you showed me falsified injury pictures of Almont Police officers Wilson and Best that you falsely claim I caused. I've asked you for all evidence when I became my own attorney. Start over again. I have asked for all evidence when I became my own attorney in June of 2020, and your department has failed to comply ever since. In an envelope dated 4/20/22 that you sent to my old address and was forwarded to my new address on 4/24/22, which was 2 days before my trial was supposed to begin, you sent me a letter stating the People's Exhibit list that mentions 5 photographs and 2 DVDs that I never received. I never received the warrant that you intentionally and maliciously swore out for my arrest for failure to appear for opening day of my trial that I have battled your department to get for almost 3 years when you know it's a complete and utter lie. You had full knowledge of my 16-day Secretary of State mandated interlock device failure, and you used it as a weapon to attempt to destroy my case that you can't win honestly. I've been asking you for evidence that is crucial to my defense, and you have refused in violation to the Brady Rule. And here's the Brady Rule. The Brady Rule, named after Brady versus Maryland, requires prosecutors to disclose materially exculpatory evidence in the government's possession to the defense. The Brady material or evidence the prosecutor is required to disclose under this rule includes any evidence favorable to the accused. If the prosecution does not disclose material exculpatory evidence under this rule, the prejudice has ensued, the evidence will be suppressed. Mr. Miller, you must suppress your fake evidence. I've been asking Mr. Miller for that evidence since June of 2021. The evidence will be suppressed, whether the prosecutor knew the evidence was in his or her possession, or whether or not the prosecutor intentionally or inadvertently withheld the evidence from the defense. Further, in cases subsequent to Brady, the Supreme Court has eliminated the requirement for a defendant to have requested the favorable information, stating that the prosecution has a constitutional duty to disclose. Let me repeat that. The prosecution has a constitutional duty to disclose. But the Lapeer County doesn't understand the Constitution or the Bill of Rights. Prosecutors are required to give the defense all evidence, including evidence that may be favorable to the defendant. Unfortunately, the prosecution sometimes plays fast and loose with exculpatory evidence. And if the defense doesn't know the evidence exists, it may be hidden by the prosecution and not available in discovery, leaving the defendant at a disadvantage. Brady versus Maryland also requires that the prosecutor disclose evidence that the prosecution knows or reasonably should have known would cast doubt on a prosecution witness's testimony. Disclosure under Brady and the ethics rules promulgated by the California State Bar are important components of our justice system and help ensure that we live under the rule of law, not under the rule of man. Lapeer County still doesn't understand that. Prosecutorial misconduct. Has withholding evidence become common? Prosecutors have a constitutional duty to turn over any exculpatory evidence to the defense. The Supreme Court held that a defendant must have the right to have evidence found by the prosecution revealed to the defense, and when the evidence has the potential of affecting the outcome of the criminal case. You don't think fake pictures of Almont Police would affect the outcome of my criminal case? However, the prosecution failed to reveal this crucial information to the defense. This is termed a Brady violation. As Judge Kaczynski bluntly put it, there is an epidemic of Brady violations abroad in the land. Only judges can put a stop to it. And that's what Judge Holoka of the Lapeer County District Court has to do Monday the 13th at 1:30 p.m. Mr. Miller, unless my state-mandated interlock device fails again, I will be in your court Monday, June 13th, 2021 at 1:30 p.m. demanding my right to a constitutional speedy trial that as of today you have dragged out for 1,006 days, and that's 2 years, 9 months, and 1 day in violation of my constitutional right to a speedy trial. In 1,006 days, I have never been to court yet. How is that possible? I have never been to court. I've never sat in any of your district or court hearings and heard your side, my side, or anything regarding my case. I've been my own attorney since June of 2020. I've never been able to present any evidence crucial to my defense. I gave you my evidence to you on January of 2021. You have done nothing with it, John. Why? In June of 2020, I had a remote Zoom hearing in Judge Barnard's court. I was in my own home, and I couldn't hear anything. I asked Judge Barnard when I was finally going to court, when I was finally going to trial. I said her court was in violation to my habeas corpus right to a speedy trial, and I was immediately thrown out of Judge Barnard's COVID court. And I made a video of that too, and it's posted on my Almont Senior YouTube channel. And I have a right to film anything I want in my own home. Mr. Miller, you have my evidence. You've had my evidence since January 2021. You've never refuted any of it. Why? I thought you were on my side. How is it possible or legal to drag out my case for almost 3 years and I've never been to court yet? John, the day I met you in January 2021, I handed you what is now over 140 evidence videos that prove my innocence. And Lapeer County DHH Supervisor Rhonda Lansing's intentional gross negligence that is responsible for destroying my home at a cost of $15,000. And Social Security fraud by committing me to Medicare Part B against my will, without my signature, and over my vehement demands that I did not want Medicare Part B that cost me over $12,000 to date. And I forgot to add this too. When I was thrown in a mental institution, after I was thrown in jail for 2 weeks, I went on a 2-week hunger strike, so Lapeer County shipped me off to McLaren Geriatric Medical Ward in Bay City for another 2 weeks, and I demanded to be released, and I had a lawyer come in, and he told me that they could keep me indefinitely unless I signed my Medicare Part B immediately, or they would keep me indefinitely. So they forced me to sign my Medicare Part B at that time, and that's the only way they let me go. Okay, I'm going onward. She committed Social Security fraud by committing me to Medicare B Part B against my will, without my signature, and over my vehement demands that I did not want Medicare Part B, and that cost me over $12,000 to date. I've got videos going back from all the way from the beginning when I complained to Rhonda Lansing, and then I got involved with the Adult Protective Services, and I had an Adult Protective Services agent that was working with me, and he was supposed to be investigating all this stuff. He didn't do anything. That's $27,000 Rhonda Lansing did to me in less than 2 months after applying for benefits in November 2016. And then Rhonda Lansing left me to die without drinking water for over 2.5 years. The Lapeer County Mental Health Law Enforcement Liaison Danielle Giles finally got a plumber to get my water running in March of 2020 after 2.5 years of being without water for simple survival. I showed Danielle Giles my ADA, that's Americans with Disabilities Act, federal and state legal right to transportation to access public services, which includes transportation to attend court. So her department provided transportation to allow me to successfully attend all court hearings in Lapeer County. This is another incident. In May of 2019, I was out of drinking water for over 6 days, and I attempted to drive my vehicle without a license and insurance to get drinking water. But I was arrested by Michigan State Police Officer Lentini and was taken to Macomb Jail. He just had a license plate reader that showed that my insurance was expired. Officer Lentini refused to allow me to take my wallet to jail, so I didn't have the $100 bail to get out. I went on a hunger strike and was held for 6 days in Macomb Jail until Macomb Jail guards came into my cell and beat me up so bad that the jail sent me to the hospital. The hospital confirmed the jail guards damaged my existing back injuries. Macomb Jail forgave the $100 bail, and 2 Macomb police officers drove me all the way to my house. Almont Police used the fact that I had a warrant out for my arrest in Macomb County as an excuse to stalk and arrest me on 9/8/19. The reason I had a warrant for my arrest is because my court-appointed attorney, Dan Guerin, gave me the wrong date for court, and when I didn't show, he lied and told Judge Viviano that I failed to appear, so she issued a warrant for my arrest. I made video evidence of my Macomb case and forwarded it to the Almont Police Chief, Andy Martin, and former Lapeer prosecutor, Mike Sharkey, showing exactly what happened. I went on to finally beat that case in Macomb County because the Macomb County Judicial System finally realized that a crisis is not a crime. The Lapeer County Judicial System isn't as diligent. They're still trying to prosecute me 15 years to life for trying to get water, so I don't die drinking water. Almont Police Officer Ryan Wilson stalked me on 9/8/19, knowing that I was out of drinking water for over 5 days because Lapeer 911 and the Human Development Commission, which is a help group, told Almont Police that I called both agencies begging for drinking water and protection from Almont Police on 9/7/19, the day before Ryan Wilson stalked me. I also filed a U.S. Justice Department complaint, police abuse. I also filed a U.S. Justice Department police abuse complaint against Almont Police on 8/31/19. That's 8 days prior to Officer Ryan Wilson stalking me on 9/8/19. In the Almont Police and former Lapeer prosecutor Mark Sharkey, In the Almont Police and former Lapeer prosecutor Mike Sharkey used it as a way to shut me up and finally stop me from making gross negligence complaints against Lapeer County employees. Prior to 9/8/19, I forwarded evidence videos of Dan Guerin's false testimony to Almont Police Chief Andy Martin, who told me he watches all my evidence videos. Almont Police Chief Andy Martin had no reason to have his police officers stalk me. Rhonda Lansing's intentional gross negligence has cost me $15,000 damage to my home, and her Social Security fraud cost me over $12,000 to date and has encumbered me for the rest of my life. I have to pay $147 for the rest of my life for something I never wanted, I never used. Corrupt Lapeer County has covered up Lapeer DHH supervisor Rhonda Lansing's Social Security fraud and are destroying my home. And she did all that damage within 2 months of applying for benefits in 2016. And that was after, in 2016, the state of Michigan allowed me to buy a car, plate it, and insure it, and then told me that I couldn't drive it until I paid $4,000 in driver's oversight fees that go back 21 years. And 2 years later, they rescinded that law, calling it parasitic and abusive to Michigan taxpayers. But that was too late. Mr. Miller, please give me all your evidence, including the falsified pictures of Almont Police's fake wounds Monday. Respectfully, Almont Sr., my new address, somewhere 3 hours from Corrupt Lapeer County, and my phone number. Respectfully, Almont Sr., and I put my new address somewhere 3 hours away from Corrupt Lapeer County. I put my email address and cell phone and office phone.